Oh, good evening, everyone. I'm Samuel Wong, the moderator for this session. We are very grateful today to have with us Mr. Wilson Lui. The talk of this particular seminar is entitled International Arbitration and Conflict of Laws. Mr. Lui is a legal scholar, a lecturer at the Hong Kong University, as well as the City University of Hong Kong. He's the author of a new book, Hong Kong Private International Law, which he authored this together with Mr. Anselmo Reyes, former construction judge of Hong Kong, and also a judge of the International Commercial Court in Singapore. So without more, I will hand over time to Mr. Lui. Shall we give Mr. Lui a round of applause?
Thank you. Thank you, Mr. Wong, for the kind invitation. And it is a pleasure to be invited by the Hong Kong Institute of Arbitrators to deliver this talk. As mentioned by Mr. Wong, my recent book on conflict of laws in Hong Kong provides some guidance as to how Hong Kong courts may resolve cross-border disputes in general. And today I'm going to focus on the specific aspect of arbitration, what cross-border issues might arise in the aspect of arbitration, and how we are going to resolve that, drawing mainly from the experience of Hong Kong, but also occasionally borrowing from cases from other jurisdictions. So I'll speak for around 75 minutes, and I think I will leave around 15 minutes for Q&A. First, I want to start by looking at some key concepts. Well, the topic of this talk is international arbitration and conflict of laws. Terminology aside, we can treat conflict of laws and private international law as interchangeable for now. We can say both of them are domestic rules, rules within a particular system of law in how they are going to resolve cross-border cases that involves not only the jurisdiction itself, but also some connection with other jurisdictions. So although they are domestic rules, the word international is there to reflect the cross-border nature of the subject. There's, of course, also harmonization or cross-border uniform rules in relation to how these matters are dealt with, and therefore the international aspect of the subject can also be reflected from this aspect as well. But the second part of this talk is about arbitration. And if we talk about international arbitration, of course, we can realize a certain aspect of cross-border element in it, whether it is the parties who come from different jurisdictions, or is it the matter in dispute that involves transactions in different jurisdictions that lead to a problem regarding both the jurisdiction of the arbitral tribunal and the choice of law that the tribunal will choose in order to decide the procedures as well as the substantive dispute in the arbitration. Adding to that is a layer of the court's intervention. First, we have the supervision court, the court at the seat of the arbitration, which exercises some control, although limited control, on the arbitral proceedings conducted within their seat. But there's also the recognition and enforcement aspect of that, where awards may have to go to somewhere else other than the seat of the court, seat of the arbitration, and will therefore need to be sought recognition and enforcement. We know that the New York Convention has provided a very successful framework in developing recognition and enforcement of awards. But I want to go beyond this traditional framework by talking to you about a theoretical framework that I've recently read by Emmanuel Gallard in 2008 in the Hague Conference. We've often seen arbitration as a national subject, an issue that can be controlled or is subject to some national laws within a particular jurisdiction. For example, in the seat court, we will consider whether the arbitration is conducted properly, is there due process, and so on. In the recognition and enforcement court, the enforcing court will definitely look at the arbitration and how it was conducted before deciding whether to grant recognition and enforcement of award in that process. But we can think further from that by saying that there is also actually a transnational arbitral order in that sense, and that's what Professor HKIArb favors as the theory for arbitration. There may be international or transnational principles commonly accepted by many jurisdictions in looking at the question, not limited to a particular court or a particular view, for example, in the common law or in the civil law. Professor Reyes, in his book in 2017 by Routledge, has mentioned an example of a company signing an agreement by its subsidiaries. If we consider Hong Kong law, for example, then we will need to consider questions like piercing the corporate veil. We'll need to consider questions like corporate issues in order to discuss whether the actual company is bound by the agreements, or who can we be held responsible for this agreement. But there are also, if we take a transnational view, then it is not necessary for us to limit ourselves to the view of a particular court, be it the seat court or the enforcing court, for example. We could derive, for example, more generally accepted principles that may be applicable in international arbitration. And that is a view that might be the ideal in the future. Although for now, we can see a lot of examples where conflict of laws rules or private international law rules in Hong Kong has affected how we looked at this question. And therefore, it's the focus of this talk to deal with the intersections between the national laws as well as international arbitration. It might interest you to know that the International Law Association has set up a committee last year in 2024 to specifically deal with conflict of laws issues in international arbitration. I'm just putting up to show that there is international recognition of how important this issue is to practitioners. And therefore, it might be something that you want to think about in the next hour or so. My structure of this talk is going to focus on 4 specific issues. I'm going to talk about, first, the choice of law in subject matter arbitrability, a question that is often neglected, but although it's of some importance nowadays, because there are increasingly a number of disputes where we want to discuss whether it can be subject to the discussion or the jurisdiction of an arbitral tribunal. Secondly, I'll talk about the choice of law in arbitration agreements, a topic that has already been discussed in many other seminars, I believe, but I'm going to summarize a few key decisions with you and to look at how that question might be approached in the future. Third, I'm going to talk about the jurisdiction and the choice of law issues that might arise within an arbitral tribunal. I'm going to refer basically to the Hong Kong arbitration framework and try to make sense of how the arbitral tribunal can decide a case effectively by looking at not only a specific national law, but also other rules or other rules of law that the arbitral tribunal considers appropriate. Lastly, I will look at recognition and enforcement of arbitral awards. Of course, you can envisage how this will be relevant to conflict of laws or private international law, because it is exactly where an award that has been given at the seat court, at the seat of the arbitration, that has to be going to somewhere else in order for that to be enforced. So that, of course, hinges on how we discuss or how we look at the arbitration conducted in another place or another jurisdiction. By jurisdiction, I, of course, refer to it in the private international law sense. So Hong Kong, Macau, Taiwan, and mainland China will each constitute an independent jurisdiction for this purpose, although, of course, we recognize it as a sovereign state in total. Let me now turn to the first topic on subject matter arbitrability. If you think about the question of arbitrability, it's quite curious because we don't really have a consensus as to what matters are arbitrable and what matters are not. Generally, if we want to define arbitrability as what matters can be decided by a private consensual process, then we can imagine quite a lot of these matters could potentially fall within arbitration. Although if we are talking about matters with a public interest, for example, family law, taxation law, criminal law, immigration, or anti-competition, for example, then these matters with a public interest element or public element may not be suitable to be determined by a private consensual process. However, we seem to have quite the common sense about arbitrability, and therefore, at least in most national laws, we don't really have a list defining what matters are arbitrable. According to common law cases, for example, in the Singapore case of Tom Lugan Holdings, there seems to be a presumed arbitrability. As long as parties, reasonable parties, have agreed in advance that such matter is arbitrable, then it is presumed that it will be arbitrable unless, for example, it is contrary to some kind of parliamentary intention or indication that these matters should be reserved exclusively for the national courts. Or maybe there's some public policy reasons or reservations which makes it impossible for these matters to be arbitrated. In Hong Kong, we also have cases, for example, in the company law context, where Justice Harris in Quicksilver Greater China case, for example, talks about how the essence of arbitration is to resolve the substantive dispute or the commercial disagreement between the parties. So therefore, the fact that, for example, a relief is not possible to be granted by the arbitral tribunal does not matter that much. The important thing is that if we are looking at the disagreement, which was previously agreed to be resolved by arbitration, then it is more than likely that the matter will be stayed for arbitration in order for that dispute to be determined first. As proven by recent Hong Kong cases like Falcon Insurance, the fact that the arbitral tribunal do not have the power to grant certain relief, exclusive reserve to the courts, does not make the subject matter non-arbitrable. You will still have to respect the agreed dispute resolution method given by the parties in advance. So, for example, I'm just listing out some cases which kind of discuss how arbitrability has been mentioned in Hong Kong. We will recall a 2008 CFA case, the Bequito Lima Button case, which talked about how the courts are reluctant to send a matter to arbitration because it is dealing with employees' compensation under the exclusive framework under the Employees' Compensation Ordinance, CAP 282. The court felt that if the matter is allowed to be going into arbitration, then it will deprive the employees from the protection of the statutory framework of employees' compensation. As for disputes concerning shareholders' rights, it depends really actually on the agreement, whether the shareholders' agreement, for example, is wide enough to cover the disputes being envisaged. So, for example, in Dixon Holdings, a 2019 case, Justice Godfrey Lam was talking about how the shareholders' agreement was unable to cover a matter that was discussed in that dispute. But in the case of PI1 and MR, a very recent case which cited Dixon Holdings, it was talking about how the matter is interpreted to be within the arbitration clause so that the matter will go to arbitration. So there's no one-off or a tight approach or a stringent approach as to whether company law matters are arbitrable or not. It all depends on the arbitration agreement. The following line of cases, re Guy Lam, re Simplicity and Vogue, CM participation will all be familiar to some of you who have some discussion about debts subject to an arbitration agreement, which forms the basis of a liquidation or a winding up petition. In those cases, the party is seeking to wind up a company, but the other party says the petition was based on a debt which was by itself subject to an exclusive jurisdiction clause or an arbitration clause, making it impossible to be resolved by the court, but rather have to go through the agreed dispute resolution method. We know in 2023, the Court of Final Appeal in Hong Kong has finally settled on this matter by saying that generally the dispute resolution clause should be respected unless there is issues that are bordering on frivolous or abusive process, which makes it impossible to be said that the party is genuinely disputing the debt. And in Simplicity and Vogue holdings, we are talking about how the holding in Re Guy Lam extends to arbitration clauses. So Re Guy Lam was a case that talks about exclusive jurisdiction clauses, and we have the confirmation from the Court of Appeal later about how the same reasoning applies to arbitration clauses. Sun Entertainment Culture Limited is an example of how this works. In that case, the defendant was raising a defense under the Moneylenders Ordinance, Cap 163, and the Court of Appeal thought that such defense was bordering on the frivolous or abuse of process term that was framed by the Court of Final Appeal in Re Gai Lam, and therefore dismissed that stay for arbitration. It was held that the petition must proceed. As we know, in CM participation, a UK Privy Council case, the issue was the UK Supreme Court decided to follow another approach, where it was required to show a genuine debt or genuine dispute as to the debt before the parties can proceed with the arbitration or dispute resolution process. But if we read carefully the decision of CM participation, it might be said that the difference between the two tests may not be that wide. It might seem that they are actually talking about a similar test, and eventually it depends on a fact inquiry basis. It is on the facts of the case that parties need to decide whether this will be a case where the dispute has to be deferred to arbitration. Remega Gold Holdings is the most recent case by Deputy High Court Judge Richard Kaur SC on following Re Gai Lam as a matter of stare decisis, because it was decided by the Hong Kong Court of Final Appeal. So, just Deputy High Court Judge Richard Kaur was also talking about how it would depend on a factual inquiry, and that's the point I've just emphasized about. There's also an interesting point on intellectual property rights, which I want to mention, because in Hong Kong and in Singapore, we have statutory provisions deliberately designed to provide for arbitrability in intellectual property rights, expressly stating that claims related to IP rights are arbitrable, and to recognize and enforce awards relating to IP rights are not contrary to the public policy of the respective jurisdiction. So that is also one way of providing for arbitrability of disputes. I've now spoken so far about the law of Hong Kong on how we decide on arbitrability. But the conflict of laws question here is, what law should we use to decide whether the dispute is arbitrable or not? Do we look at the law of the seat? Or do we look at the law of the arbitration agreement? Or do we look at the law of the forum? For example, when we are enforcing an award, do we look at the law of the enforcing court in order to decide whether it has arbitrability? Presumably, if parties have agreed to arbitrate based on the law of X, then when the award goes to another state, state Y, then the law of state Y should presumably not affect the decision under the law of state X on ruling that the matter is arbitrable. However, there seems to be different opinions as to how or which laws should govern arbitrability. Arguably, if we think about more philosophical questions, why should there be an issue of arbitrability? It's because states want to protect their local interests. They don't want matters that has a public element, or matters where the state has an interest in those matters to be arbitrated by a private consensual process. So presumably a court should only be interested in invoking an arbitrability exception only when the dispute concerns something that affects their own state, but not other states. So that becomes a matter of discussion in recent years. I just want to point to one important case, a recent Singapore Court of Appeal case called Anupam Mittal and Westbridge Ventures to Investment Holdings. That case concerns a claim of minority oppression, which was launched in Mumbai in India. It was before a national company law tribunal, a tribunal set up in India to resolve these claims. And the Singapore court has to decide whether the claims were arbitrable, because the parties went to the Singapore courts to ask for an anti-suit injunction. They are trying to restrain the Indian parties from continuing with the claims in India. Rather, they want the claims to be arbitrated in Singapore. the Singapore Court of Appeal thought that the dispute cannot be arbitrated only if both of the elements are satisfied. First, if either of these elements are satisfied. First, if the arbitration agreement is expressly governed by foreign law, which provides for non-arbitrability, or if the law of the seat does not permit arbitrability. So the Singapore Court of Appeal in that sense took a composite approach, because the Singapore Court of Appeal is looking at both the law governing the arbitration agreement as well as the law of the seat. Failing to claim arbitrability in either of these laws will be a breach of public policy. So they're looking at both systems of law, and they're saying that the parties should actually look at both systems of law before deciding whether to claim for that, or during contractual negotiation, they have the duty to look at these matters. That decision was based on the International Arbitration Act in Singapore, where Section 11 says that any dispute may be determined by arbitration unless it is contrary to public policy to do so. So what the Singapore Court of Appeal was saying, that by saying in the Section 11 that it is contrary to public policy, it means both Singapore public policy, the public policy of the seat court, and also foreign public policy. So if we want to respect the foreign public policy, we will also need to consider the law of the arbitration agreement, which provides for arbitrability or non-arbitrability in that regard. So we are taking a different approach from other situations, at least in the situation where it is before the award. The court will have to consider arbitrability by looking at both laws. Just summarizing what the decision of Anupam Mittal eventually in the Singapore Court of Appeal. The Court of Appeal has to decide first what is the governing law of the arbitration agreement. It held that there was no express choice of the governing law because the main contract, the choice of law in the main contract, would not affect this question. I'll talk about this more later. There will be no implied choice of governing law of the arbitration agreement. And on this basis, the Singapore Court of Appeal referred to the fact that Indian law would have held the matter to be non-arbitrable because the National Company Law Tribunal, the NCLT, would have exclusive jurisdiction over the minority oppression claim. So the matter will not be arbitrable in India, and it will not be the intention of parties to do that or to use Indian law, because if so, then the arbitration agreement will be defeated its purpose. So eventually, the Singapore Court of Appeal decided that the governing law was the law with the most real and substantial connection to the arbitration agreement. That is the law of the seat, which is Singapore law. So by applying the test I've just mentioned just now, where a dispute non-arbitrability have to be decided with respect to both the law governing the arbitration agreement and the law of the seat, the court eventually held that both of these laws are Singapore law. And under Singapore law, the minority oppression claim is arbitrable in Singapore. And therefore, the Singapore Court of Appeal decided to grant the permanent anti-suit injunction. Now, remember, in this case, under Singapore law, the matter would be arbitrable. But under Indian law, it would not be arbitrable because the NCLT would have exclusive jurisdiction. So that becomes a kind of jurisdictional dispute or quarrel between the Singapore court and Indian court. In fact, subsequently, the Bombay High Court in India has held that the Indian law would have governed the arbitration agreement, and therefore would have said that the matter was non-arbitrable under Indian law because it will be subject to the NCLT's jurisdiction, and actually granted what is in effect an anti-suit injunction. It prevents Singapore from deciding further on the claim, and the NCLT itself granted an anti-arbitration injunction, an injunction that forbids the parties from continuing with the Singapore arbitration. Now, these words, anti-suit injunction, anti-arbitration injunction, might sound very fancy, but you will understand that these are very against comity reasons, right? Respect towards each other's states, each other's courts in launching these kind of injunctions. And in Hong Kong, in China, for example, we have intellectual property disputes where China and US are engaged in anti-suit injunctions, for example. Of course, that's a way or tactic of how courts can decide on that, because those injunctions are only effective against the person. So in one sense, you can say it is not out of disrespect to the court, but in another sense, you may say it reflects how complex our international dispute resolution landscape is, because different courts are trying to engage with their own jurisdiction and try to be sort of active in trying to resolve the disputes before the parties. So if we look at Mittal again now, we see there is a difference in the choice of law in arbitrability. What Mittal eventually decided was that in the pre-award stage, we have to apply the composite approach. Originally, we only looked at the law of the forum, the law of the sea. As I mentioned at the beginning, the reason why we are concerned with arbitrability is because it will affect the matters or public interests of that particular local state. So traditionally, we only need to look at the law of the seat in order to decide arbitrability. But as you can recall, in 2023, the Singapore Court of Appeal decided that we need to look at both the law of the arbitration agreement and the law of the seat to determine arbitrability. At the post-award stage, we look at the law of the forum, which is usually the enforcing court, the court which is required to enforce the award. So this difference seems to be a bit difficult to understand, because supposedly, if you want to challenge the arbitrability before the award and challenge the arbitrability after the award was made, should not be different. They should not use two different tests to decide on this matter. And a similar concern has been expressed in the UK Supreme Court case of Anchor and Chubb in the context of choice of law in arbitration agreements. Now, Singapore Court of Appeal in Mittal noted all of these. These are all concerns that the Singapore Court of Appeal noted, but they put priority to public policy, or what they think to be public policy, in saying that we have to respect the non-arbitrability question in both of those states. So therefore, it seems that Singapore Court of Appeal has used non-arbitrability under the foreign law in two different ways. The way to expand non-arbitrability or considerations of these non-arbitrability in the pre-award stage, but at the same time thought it is important by doing it as an implied governing law, or doing it away as the implied governing law of the arbitration agreement. That was a recent development which I want to share with you, because the Singapore Court of Appeal seems to have make it a more complex question. But in Hong Kong, for example, or other supervisory courts, I suggest the approach might be easier, because usually the supervisory courts at these seats might simply defer the question to the arbitral tribunal. The tribunal, having its competence, its jurisdiction, its own jurisdiction to deal with whether it has jurisdiction, can decide on the question of arbitrability itself based on the law governing the arbitration agreement. As we recall, arbitration is all based on the arbitration agreement. The power of the arbitral tribunal derives from the arbitration agreement itself. And therefore, it is necessary for the tribunal to come to a decision on that ground. It seems that Singapore Court of Appeal has taken a more complex answer on this question. But that's all I want to share about arbitrability, which might be a heavier topic. The second topic I want to share is arbitration agreements and the choice of law within that. I'm sure some of you have already attended relevant seminars on this, so I will be more brief on this. But I first want to emphasize a few concepts in arbitration agreements. First, there's a concept of separability and severability. It is a fundamental concept to understand that an arbitration agreement or arbitration clause is separate from the other terms of the contract. It is an independent agreement by itself, and it is still valid despite you have objections to the existence or the validity of the main contract. It is a concept recognized not only for arbitration clauses, but also for other kinds of jurisdiction and dispute resolution clauses. I've cited some authorities here. Therefore, if we take this separability principle as a starting point, then we can also say that the governing law of the arbitration agreement can theoretically be different from the governing law of the main contract. the fact that the law of the main contract is the law of X does not necessarily mean that the choice of law for the arbitration clause is also X. Well, of course, the easiest solution that you can now think of is that it should include a governing law for the arbitration clause, just to have a separate provision to say that the governing law of the arbitration clause is the law of X. However, if we look at recent statistics, I've cited from Gary Bond's treatise on international commercial arbitration, but also a more recent journal article by Michael Huang SC and others, that we can see around 80% to 90% of the current cases do not have a separate governing law provision for the arbitration agreement. It seems to be conventional legal wisdom that whatever law that governs the main contract would also govern the arbitration clause. But we have a list of long line of cases which says this was not necessarily the case. There were many cases which shows that there may be problems in deciding what is the choice of law of the arbitration agreement. But the takeaway message for now, of course, is if we include an express governing law for the arbitration clause, then certainly that will be respected. In whatever case that I'm going to discuss with you in the following 10 minutes or so, the courts all emphasize that party autonomy should be respected. As long as the parties agreed that a certain governing law will apply for the arbitration clause expressly, then certainly that governing law would be applicable to the arbitration clause. I've mentioned already that there are a lot of decisions. I'm going to bring to your attention to 6 of them. The first case is called Sudamerica and Anisa, a 2012 England Court of Appeal case where there was a main contract expressly governed by Brazilian law, but the seat of arbitration was London. Again, there was no express governing law for the arbitration clause. So the court has to decide what is the governing law of the arbitration clause. The Court of Appeal clarified the approach by saying that the governing law of the main contract can be a strong pointer for that governing law to be the implied governing law of the arbitration agreement as well. So following the conventional legal wisdom in some sense, but there were specific factors in that case, in the Sudamerica case, that made it impossible for the court to come to this conclusion. The Court of Appeal in that case provided for 2 such factors. First, it was saying that because the parties are talking about London arbitration, presumably that means the English Arbitration Act would apply to that arbitration, and therefore the English law seems to be more appropriate as the proper law of the arbitration agreement, rather than Brazilian law, which governed the main contract. Secondly, there were some problems with Brazilian law concerning the condition precedent or the consent matter, which made it a serious risk that the Brazilian law would significantly undermine the arbitration agreement. So despite the strong pointer that we said in the earlier of this case, it seems that eventually the Court of Appeal decided that English law would govern, the law of the seat would govern the arbitration agreement, but not the governing law of the main contract. So that was the first case where we see a tension between the law of the arbitration agreement and the law of the main contract and the law of the seat. The second case, and in each of those cases, I'll just mention what is the seat of arbitration and what is the governing law of the main contract. In the Singapore case of BNA and BNB, the main contract was governed by PRC law, and the seat of arbitration was Singapore. Again, there was no express choice of governing law of the arbitration agreement. The Singapore court decided to adopt the Sudamerica approach and say that the PRC law would govern the arbitration agreement. Under PRC law, the arbitration agreement was invalid, and therefore the arbitration agreement was held to be invalid. The parties, of course, tried to argue for a displacement, like the Sudamerica case, but the Court of Appeal held that it was insufficient to displace the conclusion because the parties were not shown to be aware that the choice of proper law of the arbitration agreement could have an impact upon the validity of the arbitration agreement. So it was saying that the parties have to be aware of these matters in order to hold that the choice of law was something else other than the law of the main contract. I just mentioned, put a note here about the Anupa-Mittal case, because in Anupa-Mittal, there was also discussion about how this conclusion might arise. So that will be a pointer as well. The third case is the well-known case of Anker and Chubb in the UK Supreme Court in 2020. In that case, the main contract had no express governing law, and the seat of arbitration was London. So in Anker and Chubb, the question is more complex now because we don't even have a governing law for the main contract. And therefore, the Anker and Chubb, there was a tiered approach proposed by the UK Supreme Court, holding that if we do not have an express choice of governing law of the arbitration clause or an implied choice of governing law of the arbitration clause, then the governing law of the main contract should theoretically apply to the arbitration clause. It could be express, of course, but in that situation, in the Anker and Chubb situation, there was not even an express choice of governing law in the main contract. And therefore, it was the search for the implied choice of governing law of the main contract. If everything fails, then we apply the law of with the closest connection to the arbitration agreement. And that is where the UK Supreme Court was divided 3-2. The majority said that the law with the closest connection to the arbitration agreement should be the law of the seat, while the minority say that the law with the closest connection to the arbitration agreement should be the law of the main contract. That is where the divergence occur. But remember that before that, we have to look at whether we can find a governing law for the main contract, whether express or implied. If we can find that, then this divergence does not arise. Following Anker and Chubb, there was also another case, Kebabji and Cold Food, decided just 1 year later in the UK Supreme Court, where the main contract was expressly governed by English law and the seat of arbitration was Paris. The UK Supreme Court there simply applied the principles in Anker and Chubb and say because there was an express governing law of the main contract, which is English law, the English law governs the arbitration agreement. Kebabji was interesting because it was also litigated in the French courts, and the French position is diametrically opposite to the English position. The French position in the Cour de Cassation in 2022 held that absent the express choice of the law of the arbitration agreement, it is the law of the seat, the French law, which governs the arbitration agreement, but not the express or implied choice of the governing law of the main contract. So we can see now that English takes a different approach from the French and also the German courts in that regard. Two more cases. The fifth case is the Hong Kong case of China Railway and Chongqing Holdings. I think for now, it's the only case that discusses the potential applicability of these cases in Hong Kong. In that case, the contract was governed by Hong Kong law, and there was a non-exclusive jurisdiction clause of Wuhan. So strictly speaking, it is not deciding on the matter of arbitration clauses, but it was the only case which endorsed the majority principles in Anker and Chubb, held that they were applicable in Hong Kong and extended them to jurisdiction clauses. So it was held that the governing law of the main contract would also govern the effect of the non-exclusive jurisdiction clause in that case. The final case is UniCredit Bank, a more recent case in the Supreme Court in 2024, where there was a main contract governed by English law and a seat of arbitration of Paris. In that case, UniCredit, again, the Anker and Chubb principles were applied and held that the express governing law of the main contract, English law, would govern the arbitration agreement. In UniCredit, it was also reinforcing the potential exceptions to this inference, and that inference was exactly the one we see in the SulAmérica case. That is, if there's an existence of a serious risk that the arbitration agreement, if governed by the same law as the main contract, would be held ineffective, then it will be a factor showing that the arbitration agreement should be governed by the law of the seat instead of the law of the main contract. Now, I've gone through the common law position, which seems to be complex, and therefore the English legislative or the Law Commission has proposed a reform. The reform will make it simpler by neglecting what I've just said just now, by saying that now we have a new position in the Arbitration Act, which provides that the law applicable to an arbitration agreement is the law that the parties expressly applied to the arbitration agreement, or if there is no such agreement, simply the law of the seat of arbitration. So it does not go through the three-stage process I've just outlined in the Anker and Chubb case, but simply saying that if we don't find an express agreement, then the law of the seat of arbitration will apply. Section 6A2, which will be inserted as well into the Arbitration Act, provides expressly that the governing law of the main contract would not mean a governing law of the arbitration agreement. So you can see that the UK has taken a legislative step to refine these rules. Of course, it is it is of course subject to some criticism, I would say, but it seems to show a simpler solution towards the question of choice of law in arbitration agreements. The Arbitration Act 2025 has already received royal assent, so it will be soon in force, and therefore the English position will definitely change. The Singapore Ministry of Law has issued a consultation paper, I think just a few months ago, and the consultation period is still underway. So it was seeking views on potential reform as well in this very complicated issue, and we will need to consider whether Hong Kong need to follow course, because presumably, if we follow the China Railway case I've just discussed, then Hong Kong would also need to follow the more complex Anker and Chubb approach. But of course, you can say that there are advantages as well, because it will first looks at conventional legal wisdom by saying that the law of the main contract would potentially apply to the law of the arbitration agreement unless there were issues regarding the validity of the arbitration. It's not that we don't have cases in Hong Kong that deals with the matter, and the usual case that we cite is the Klockner case in 2011 by Justice Saunders. There, it was a main contract governed by German law, and the seat of arbitration was Shanghai. In that case, the court eventually held that there was an implied choice of German law as the arbitration law, because the law of the main contract was German law, and failing an express indication of the governing law of the arbitration agreement, the implied choice of German law would prevail, and the arbitration clause is valid under German law. The court also noted that in this case, therefore, we are applying German law to an arbitration that is seated in Shanghai, which seems to be contradictory or complex in one sense. But the court also held that this was not always necessary. So there are situations where the law governing the arbitration and the law of the seat may be different in that sense. Importantly, there was also a principle, which I'll talk about in the next slide, about the validation principle. The parties will be presumed, without a contrary indication, to have intended the governing law of the arbitration agreement to validate the arbitration agreement. They want the arbitration agreement to be effective and resolve the matter by arbitration rather than invalidating the arbitration clause. Now the opposite conclusion, if the court comes to the opposite conclusion that PRC law governs the arbitration agreement, the arbitration clause would be held invalid under PRC law. As of now, in the arbitration law in China, it was required that you need to identify an arbitration institution in order for the arbitration clause to be valid. So therefore, had the court in Klockner held that PRC law would govern the arbitration agreement, the arbitration clause would have been held invalid under PRC law. This was still the situation, and I've also cited a more recent case in 2023, Grand Ocean, where the obiter was applied and invalidated the arbitration clause, I believe, by Justice Anthony Chan. Accordingly, PRC is undergoing a reform in the arbitration law. You may recall that we are recently drafts proposed by the Standing Committee to be discussed. In the 2021 draft to the arbitration law, the requirement was removed, so there was no longer a requirement to specify an arbitration institution. But according to the latest draft proposed by the PRC legislators, it reappeared in Article 24. So for now, we are still uncertain as to whether the requirement would be removed eventually. However, we see more discussion to be discussed here. I've talked about the validation principle just now, so I thought it would be good to just expand a little bit. The validation principle, as I've just mentioned, the court will favor a law that validates the arbitration agreement, not the law that invalidates it. So in generally, it was held that commercial parties would intend a choice of governing law to make that arbitration agreement effective. Under the new Arbitration Act in England, you will see that the validation principle has no role at all, because the Arbitration Act simply provides that absent express choice of governing law of the arbitration agreement, then the law of the seat would apply. However, as we know, because the English legislation is not applicable in other jurisdictions, of course, we will need to consider the effect of the anchor and chub principles in other common law jurisdictions. Of course, the validation principle also has its criticisms, because we are basically pre-deciding on the issue of governing law. We're saying this governing law applies because using this governing law is better because it validates the agreement. So it's kind of circular reasoning as well on the issue of governing law, and it has attracted certain academic attention as to whether the validation principle has any role outside of the arbitration context. In the arbitration context, we certainly want to encourage arbitration. We want to encourage dispute resolution, which is pre-agreed among reasonable commercial parties. But outside of the arbitration context, for example, if we have a contractual term which might validate the contract and another that might invalidate the contract, then it seems slightly more difficult to apply the validation principle in its full force. Concluding this section, I just want to say good drafting means as long as you include an express choice of governing law in the arbitration agreement, then that's fine. You can resolve all of the problems we have mentioned over the past 20 minutes or so. Parties and lawyers, I would suggest, is simply just not aware of this distinction previously. So now we have a line of cases, and therefore we can more certainly require a choice of law clause for the arbitration agreement. We need to consider whether we need a different governing law for the arbitration agreement, or is it simpler to have a governing law which is the same as the governing law of the main contract. Surprisingly, not surprisingly actually, the Hong Kong IEC has already included such a clause in its model clause since 2014. The Hong Kong IEC model clause, if you read it, includes an optional clause which specifically provides that the governing law of this arbitration agreement is the law of Hong Kong, for example. And that stipulation is important for the reasons I've just stated. Once you have an express stipulation of governing law of the arbitration agreement, many of these questions become very easy to resolve. In fact, it was reported that such a model clause has won a HKIArb award for its innovation, for its advancement or CAFARIC, foreseeing ability to see the problems or potential problems that may associate with the governing law of arbitration agreement. So the governing law of the arbitration agreement also affects the question of arbitrability. I've just discussed about how the potential non-stipulation of such governing law will lead to the court speculating whether the matter is arbitrable. If we have good drafting, certainly we can avoid some of the problems associated with arbitrability as well. So that's the second topic that I want to discuss. I'm now moving into my third one. The third one is shorter because it deals with what exactly the arbitral tribunal does and what is the jurisdiction of the arbitral tribunal. Recalling the basic concept of competence where an arbitral tribunal may rule on its own jurisdiction, including any objections as to the existence or validity of arbitration agreement. Of course, we need this concept because it avoids the philosophical question of if you don't have the power under the arbitration agreement, how will you be able to resolve a jurisdictional dispute? Competence provides that the arbitral tribunal has exactly that role to consider its own jurisdiction, and that is incorporated in Section 34 of the Hong Kong Arbitration Ordinance, incorporating Article 16 of the model law. In basically every institutional rule, you will see references to the competence principle. I've just cited the HKIArb rules as an example. If the parties are not satisfied with the interim ruling of the arbitral tribunal on jurisdiction, the party, upon application, can go to the court to review the tribunal's interim ruling on jurisdiction. That was also under Section 34 of the Arbitration Ordinance. The court there conducts an independent de novo review of the tribunal's ruling on jurisdiction, and it can receive new, relevant, and admissible evidence. So it was not limited to the original decision of the arbitral tribunal, but it can decide on the matter afresh. And I've cited two important cases in Hong Kong which discussed this de novo review. However, in the UK, as I mentioned, a very interesting legislative reform on various aspects. It also includes discussion on whether this should be remain true, whether the courts are truly necessary to conduct an independent de novo review. I'll talk more about this in the next slide, but where the parties have already argued before the tribunal on this, then it seems the courts, as suggested by the Arbitration Act 2025 in the UK, the court only has a more limited role in deciding or reviewing the tribunal's decision. Of course, it's trying to screen away unmeritorious delay tactics or applications by one party on that. But it seems that some jurisdictions are taking a different approach in terms of such reviews on jurisdiction. Now, remember, there's also another chance where the party can review on jurisdiction. You can say it is an alternative situation because in those situations, the tribunal does not rule on the question of jurisdiction immediately. Rather, it decides that to rule on the jurisdiction question together with the substantive dispute. So it issues one award that deals with both jurisdiction and the substantive dispute. In this situation, the party has recourse to the court against that award or that ruling based on a complete award. So the applicable provision is Section 81 of the Hong Kong Arbitration Ordinance rather than Section 34 of the Arbitration Ordinance. Now, cases have suggested that this is also likely to be a de novo review. If it goes to a true question of jurisdiction, then the tribunal, then the court has the right to review and receive new evidence about the tribunal's decision on the jurisdiction. But as I mentioned, the UK Arbitration Act takes a different view on this. And recently, because it's a recent legislative amendment, I think it's important to raise this. The new legislation provides that the grounds of objection or the new evidence must not be accepted unless it was proven that the applicant did not know and could not with reasonable diligence discover the new ground or prove the evidence before the tribunal. So it seems that the UK courts have taken a more limited view or limited role as to what the courts can do in terms of reviewing tribunals' ruling against jurisdiction. Singapore again issued the same consultation paper, also sought views on potential reform of this in that sense, and we do not know if Hong Kong wants to follow course in due course. But I think it's good to point out this recent development because it certainly has impact when Hong Kong is developing itself as a cross-border dispute resolution platform. It will want to stand out from other jurisdictions in that regard. For example, Hong Kong has indemnity costs against unsuccessful challenges to arbitration agreements, to unsuccessful challenges of arbitral awards. Sometimes it will be helpful in screening out unmeritorious applications against arbitral awards and arbitration agreements. So there are eventually differences among regimes, international arbitration regimes in different places. And that's where it's interesting because it attracts or it causes differences in terms of how arbitration is developed in different jurisdictions. Just listing some common objections to the jurisdiction of arbitral tribunal. Usually a party would allege invalid arbitration agreement, party lacking capacity to enter into the arbitration agreement, arbitrability problem. We've discussed that a lot in the previous slide. And I've mentioned that the arbitral tribunal can decide on its own whether the subject matter is arbitrable based on the governing law of the arbitration agreement. A party could also argue that the dispute is outside the scope of the arbitration agreement. Certainly that would not fall within the jurisdiction of the arbitral tribunal, as well as the condition precedent to arbitration which has not been fulfilled. Hong Kong practitioners will be familiar with the case of C&D decided by the Court of Final Appeal in 2023. Of course, in that case, we are talking about whether the fulfillment of a condition precedent to arbitration goes to the jurisdiction of the arbitral tribunal, which is reviewable by the courts, or is it only a matter of admissibility before the arbitral tribunal, which is not subject to the review of the courts. The Hong Kong Court of Final Appeal adopted the distinction between jurisdiction and admissibility and held that the condition precedent would only go to the admissibility of the claim before the arbitral tribunal. It does not form a question of jurisdiction of the arbitral tribunal. I've also put up here another case, the Australian case of 2024 of CBI and Chevron, where the High Court of Australia took a slightly different approach, not employing the distinction of jurisdiction and admissibility, but rather just returning to the parties' agreement and deciding the case based on the parties' agreement to arbitrate. Some scholars have argued that this presents a more persuasive view in terms of how we should decide on questions of jurisdiction and admissibility. But it will be an interesting discussion, or going forward, it will be interesting to see how this distinction would actually work in terms of future judicial practice. Turning now to the second half of this question regarding choice of law of the arbitral tribunal. As we know that the law governing the procedures of the arbitration can be different from the law applicable to the substance of the dispute. The governing law of the substantive dispute may be different from the law where the arbitration is to be conducted. We usually use the seat of arbitration to talk about where the arbitration is seated. In the model law, the word used is place. So by place of arbitration, we are referring to what kind of law would govern the arbitration. And the law determining the procedures of arbitration is based on the seat of arbitration. That is usually the case, unless, for example, you want to have a Hong Kong seated arbitration, but you want to apply PRC arbitration law to govern that. So that might be an unusual situation, but usually we use the seat of arbitration to decide on the matters relating to how the arbitration is to be conducted. We actually have specific provisions talking about how the arbitral tribunal can choose its procedural rules. Section 48 of the Hong Kong Arbitration Ordinance incorporates Article 20 of the model law, which says the place, or if you think about it, the seat of arbitration is agreed by the express choice of parties, or if failing such agreement, by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. So it is also necessary to look at how the parties will be most benefited by or most convenient by using the relevant rules. But of course, we are also saying that the arbitral tribunal can meet at any place, using in a casual sense. For example, if we need to receive evidence from a witness, which might be present in another jurisdiction, it might be remote, it might be online, or maybe some members of the tribunal would have to go to another place in order to hear witnesses or present or receive documents or so on. But that place is used in a more casual sense. We are usually talking about the place or the seat of arbitration as the place where the law governing the procedures of arbitration is to be determined. Another provision or important provision that I want to bring your attention to is Section 64 of the Hong Kong Arbitration Ordinance, which incorporates Article 28 of the model law. This section deals with what substantive law, or what is the law that will apply to determine the substantive law applicable to the dispute. Section 64(1) provides that the substantive law is the rules of law chosen by the parties, and I quote unquote rules of law. This means that the arbitral tribunal can choose not only national laws, but also international laws, international rules, or other conventions which may potentially be applicable to the dispute. It is not necessary that the international convention be incorporated into domestic law of the seat, for example. So the parties have freedom to choose what laws or rules of law they want to apply to govern the substantive dispute. If the parties do not designate the substantive law, the arbitral tribunal will adopt the conflict of laws rules, which it considers applicable. I think this is the only reference in the arbitration ordinance to the exact wording conflict of laws. But interestingly, Section 64(2) provides that you will apply some conflict of law rules in order to determine the substantive law of the dispute. It does not say that the arbitral tribunal can directly decide on what law is to be applied to the arbitral dispute, the substantive dispute. This is called a wide indirect approach by which the conflict of law rules are selected instead of the exact national rules. So most probably, the arbitral tribunal may choose the conflict of law rules of the seat of arbitration, or the conflict of law rules of the state that is closely connected or most closely connected to the dispute, the conflict of law rules of the domicile of a party, for example, which is responsible for the performance of the contract or in a tort situation, or other kinds of international conflict of law rules that may potentially apply. But remember that we are using those conflict of law rules in order to decide on the exact national laws or rules of law to be applied to those situations. For example, the CISG may potentially be applicable if the parties have expressly chosen that, or if the seat of arbitration provides for some guidance as to how that might be incorporated. Section 64.3 and Section 64.4 talks about considerations such as amiable compositor and so on, and those are always relevant if the parties have agreed to do so. So that is a relatively shorter topic, and in the last 10 to 15 minutes, I just want to go through the remaining parts on the recognition and enforcement of arbitral awards. I'm not proposing to speak in very detail about each of those grounds because we have other textbooks or seminars talking about how each of those grounds for refusal would potentially be relevant. But I would just want to give you an overview of the recognition and enforcement regimes of Hong Kong under the arbitration ordinance and two issues that I think are more important in that situation. Under the Hong Kong Arbitration Ordinance, we know that there are different regimes for the recognition and enforcement of different awards. There were convention awards under the New York Convention, which can be recognized and enforced by Part 10, Division 2 of the Hong Kong Arbitration Ordinance. There was the mainland awards, the regime for mainland awards, which was implemented because of the arrangement in 1999 between mainland and Hong Kong on arbitral awards. And we have a supplemental arrangement, which refined on some of those provisions and led to the repeal of Sections 93 and 97, respectively, of the Arbitration Ordinance in 2020. There were Macau awards, which was implemented based on an arrangement signed in 2013, as well as the general provision if we are, for example, enforcing a Taiwan award, which would not fall within any of those provisions above. In addition to the statutory regime, we also have a common law regime. The common law regime provides that we can recognize and enforce an award based on a breach of implied promise to honor the arbitral award. And the court may grant appropriate relief beyond the award. So under the statutory regime, it is only limited to what the award has said, and the relief can only be limited to what the award has stated. But in the common law, the court may fashion a remedy appropriate to the dispute. It may be a relief that is not stated in the award itself. That common law power was helpfully clarified in the CFA case of Xiamen Xinjingdi in 2020, and would be also an interesting case in general because it would stating the position based on the common law or contractual promise. Of course, we have to distinguish this with the setting aside regime, which was Section 81 of the Hong Kong Arbitration Ordinance. In the recognition and enforcement context, we're talking about recognizing and enforcing a foreign arbitral award, an award that was not seated in Hong Kong, and a foreign party was coming to Hong Kong to seek enforcement of that foreign award. It was in that context where Part 10 of the Hong Kong Arbitration Ordinance is relevant. Section 81 or Part 9 of the Hong Kong Arbitration Ordinance was talking about the recourse of the court to the court by a party based on a Hong Kong seated arbitration. If you have a Hong Kong seated arbitration and a party was dissatisfied, it has to show the grounds based on Section 81 of the Arbitration Ordinance, which is modeled after Article 34 of the model law. As I mentioned, the basis of the recognition and enforcement of awards is to enforce the agreement of the parties. The parties have agreed to resolve the dispute by arbitration, and therefore it also contains the promise that if you obtain an award, they will be enforced against me, and the parties should be happy for that to be enforced. The statutory regimes are simply there to provide a shortcut. So you are only required to prove certain matters in order for that award to be enforced. The common law is a traditional method, but the statutory regimes above is the way to enforce that award more easily. Therefore, the enforcing court does not actually review on the facts or the merits of the award. We are not talking about trying the matter for a second time. We are only talking about whether the award should be enforced based on the previous contractual promise to arbitrate the dispute and accept whatever the arbitration results in. And therefore, if there were administration of justice concern, we can basically only resort to so-called public policy. If there are problems with the arbitration process, for example, due process, lack of notice, then those will fall within natural justice concerns, administration of justice concerns, which public policy could come into play. A recent case called GNN is interesting because in that case, the arbitrator was following a position that was not consistent with Hong Kong's position on illegality. In that case, the arbitrator was considering a position prior to the new case on Patel and Mercer regarding illegality. So they're looking at the old traditional factors or trio of considerations. The judge was not comfortable in that case to enforce the awards because it thought that the incorrect application of law in terms of illegality would be manifestly unjust or against the public policy of Hong Kong to be enforced. So that case seems to suggest a potential possibility that if a award is based on an incorrect understanding of the law, it might lead to a public policy problem. The decision was now currently subject to appeal, so we will need to see how the Court of Appeal thinks about that. But of course, we will want to make sure that we are only talking about the public policy exception in a narrow sense, as confirmed by many cases, starting from the Hebei import case, which we are all aware since 1999. We don't want public policy to be expanded into concerns of incorrect application of the law or the facts. We are trying to limit the review power to matters concerning natural justice or matters concerning the administration of justice. I just summarized the grounds here, which I don't propose to read them over, but we see that in the New York Convention, which is the major framework for recognizing and enforcing arbitral awards, there were certain grounds in which they might become a problem. The grounds stated in Article 5.1 seems to be concerned more traditionally with problems with the award. So there may be new process matters, for example, an award that might be set aside already by an authority of another country, and therefore those awards may be said to have a problem in terms of their own origin. But there's also other grounds, and the Article 5.2, the reason why we need to have Article 5.1 and 5.2 in the New York Convention is because Article 5.2 talks about more local considerations. And we only have two grounds in Article 5.2. The first ground is arbitrability, the first topic that we've discussed. If the subject matter is not capable of settlement by arbitration under Hong Kong law, then that might potentially be a problem because the local Hong Kong public policy might not allow that matter to be arbitrated, and therefore any award that attempts to arbitrate that subject matter would seem to be not recognized and enforced. But secondly, and more generally, is the contrary to public policy ground. If there are issues which is concerning the basic principles of morality or justice by the Hong Kong courts, then it would also be a problem for the courts to recognize and enforce that award. There was also a tail ground in Section 86(2)(c), but that was only a minor situation, which I think can be neglected for now. And of course, we also have to remember that establishing one or more of these grounds, for example, if we say there was a lack of proper notice or an inability to present one's case reasonably or fully, does not mean that the court must refuse recognition and enforcement of the award. Remember that the enforcing court has a residual discretion to decide whether to refuse enforcement or decline to refuse enforcement. Double negative, but saying that it will still enforce the award, even though we detect some kind of irregularities in the process. And that was stated in the Hebei import case. More importantly, and I think it's a situation that we have to be aware now, is where a party have decided not to raise a particular point during the arbitration and decided only to raise the objection at the enforcement stage. In Hebei case, there was also the important indication that each party has duty of good faith. If a party decided not to raise that point straight away, but decided to raise it later, then the party may be treated to have waived the point, or it may be treated as stopped from objecting to these matters because you have not raised the matter promptly in order to for the tribunal or for the seat court to consider those objections. If you're only raising that in the enforcing stage, that might be considered to be a breach of duty of good faith. Of course, we recognize that parties have a passive remedy and an active remedy. In the case of Xiamen Xinjili, of course, we're talking about how, in the case of Astro Nusatara in 2018, we of course talk about how a party can choose whether to review the award at the seat court or to enforce an award at the enforcing court. But the duty of good faith requires parties to raise grounds if they are there and not to breach a duty of good faith in terms of leaving the ground up their sleeves and then putting up later in the enforcement stage. In the final few minutes, I just want to talk about an interesting issue, which is to what extent should we allow or defer to the supervisory court in situations where we're discussing a decision. So in these situations, we're talking about an arbitration that was seated in a foreign place, and then the award was then reviewed by the seat court, the supervisory court. In those situations, the supervisory court may decide to uphold the award or to set aside the award. We want to look at what kind of decision or what will the Hong Kong courts do when they are faced with an award that has already been reviewed by the supervisory court. Let me first deal with the situation where the supervisory court has upheld an award. So they thought that there were no problems with the award and therefore decided not to set aside the award. In Hong Kong, the famous case is HKIArb and Kidney Holdings in 2011, the first instance judgment by Justice Reyes and the Court of Appeal judgment led by Vice President Tang. In that situation, there was a concern because the mainland Chinese arbitrator or mediator arbitrator was engaged in a med-arb procedure, which involves ex parte communication with different parties. So there seems to be a risk of apparent bias in that situation because the mediator turned arbitrator have access to confidential information that might not be available to him if he was only an arbitrator. But eventually the Court of Appeal decided that there was not a problem because the Xi'an court decision refusing to set aside the award should be given due weight. It should be given considerable weight. The fact that the mainland court did not find this should be a problem should also mean that the Hong Kong court should not be too concerned about the potential issues that might arise with it. Of course, the Court of Appeal also talked about how the understanding of how mediation is normally conducted in the place where it was conducted would also be relevant. So in mainland China, med-arb was a very popular method to resolve disputes. And therefore, if med-arb was conducted very properly in that way, there's no sense why the Hong Kong court should refuse enforcement on that ground. The reasoning of HKIArb was extended to convention awards. So in construction company and guarantor in 2021, there was a discussion where the convention courts, the state court or the seat court of convention states should also be given due weight. The decision of them, the decision of these courts in upholding the award should also be given due weight when deciding whether to recognize and enforce an award. In Song Li-hua and Li Qihong, a 2023 case which talked about an arbitrator being distracted by various Zoom conferences and not listening to the parties, the court has also this interesting observation where the supervisory court in that case has actually decided not to set aside the award, but the Hong Kong court is still concerned with public policy. It is still concerned with its own standards and law when deciding whether it would be contrary to public policy of Hong Kong to enforce the award. In that case, the award was refused enforcement because it was thought that the arbitrator was not focusing on the arguments of the parties and therefore would be a problem to enforce those awards because it would be a breach of natural justice. In that case, the acknowledgement, there was an acknowledgement that the mainland court did not set aside the award, but it does not prevent the Hong Kong court from exercising its control in terms of public policy. So despite the fact that we need to give due weight, it does not mean we are giving undue weight. We are giving sufficient weight to the decision of that supervisory court. The last part I want to talk about is the situation, the opposite situation, where the supervisory court set aside or annulled an award. Going back to my philosophical discussion at the beginning of this, if we take the validity of an award to be based on a seat court, then once a seat court has decided to set aside the award should theoretically speaking be null and void. It should be ineffective in all places because it does not render an effective arbitration. But in fact, as we can see from the common law position and first the New York Convention position, there seems to be no express prohibition on this ground. So an award, even if it has been set aside by seat court, it could still potentially retain effect in other states which have not considered the award. Article 7.1 of the New York Convention, often cited for this proposition, says that contracting states can apply more favorable provisions in their domestic laws for the recognition and enforcement of awards. So they could potentially recognize and enforce awards that has been set aside by other courts, for example. The Hong Kong case on this proposition is Dana Shipping in 2016, which applied the UK case of UCOS Capital. It says that the court has the power to enforce the power awards at common law, notwithstanding the decision of the supervisory court to set aside the award. The court can consider why the award was set aside in the seat court, actually. If it is a concern of natural justice, for example, the parties were not given any notice of the arbitration proceeding, then whatever court you go to, for example, even in the Hong Kong courts, the Hong Kong courts would have the opinion that it would be a problem to enforce that award because the party has simply not been notified. But if the seat court has set aside the award because of local reasons, for example, arbitrability, or maybe because of local public policy or fundamental conceptions of that national law, then the Hong Kong court may not have that much of an incentive to follow or blindly follow why the seat court has set aside that award. The Hong Kong court might try to revisit the issue and decide that anew. So the basic understanding is we have to consider whether recognizing those foreign setting aside proceedings would be contrary to justice or public policy. And that was the test applied in Dana Shipping. Astro Nusatara was another case which talks about the Singapore Court of Appeals ruling in its lack of jurisdiction over the additional parties. The Singapore Court of Appeal has already made a ruling in that case that the arbitration would fail because there was simply no arbitration agreement between the party and the additional parties in that case. So in the Court of Final Appeal, eventually in the Court of Appeal and eventually in the Court of Final Appeal, both courts thought that such an issue should be given due weight. The fact that the Singapore Court of Appeal has decided on this issue means that the Hong Kong court would also follow that reasoning to their regard. The last case for this talk is GNX, which talks about a re-arbitration in mainland China. Interesting one because in effect it tries to remand that arbitration back to the arbitrator for a further consideration on some procedural defects, but it does not affect the quantum of the damages being assessed, and it does not affect at all the original award. It was held that such a re-arbitration by itself does not lead to a problem in terms of enforcement of the original award in Hong Kong, and therefore would be still enforceable against the party in Hong Kong. So GNX is a recent intersection of how mainland re-arbitration procedures have an effect, if at all, on the Hong Kong recognition and enforcement. And just lastly, citing this case called KEZ and KY, a recent case I came across, which interestingly discusses all of the issues that I've come across today. Arbitrability under the PRC succession law, I believe, in that case, discussed recognition and enforcement and how should weight be given to the mainland court, as well as the choice of law of the arbitral tribunal. So I think if it's interesting as an exercise, you might say, to revisit the themes that I've discussed today, KZ and KY would be an interesting case. But it all shows how these issues are so important and so frequently occurring in our international arbitration sphere in Hong Kong. And therefore, I would invite everyone to think about these conflict of laws issues in international arbitration more in the future, and to think about how those principles might contribute to the development of Hong Kong as an arbitration hub. That's all I want to say for today, and thank you very much for listening. I'll invite any questions, and I'm happy to answer those. Thank you very much. So I think it's invited to people. I think attendees on Zoom can raise questions on the Q&A or the chat box. I think there's one, but maybe I can invite anyone in person if there are any. You have the privilege of being sitting here. If not, I can respond first to the Zoom question. Zoom question was this: does arbitration look into precedents like common law systems? I recently read an article about advantages and disadvantages about arbitration. It said arbitration only looks into case details, facts and issues, and not precedents. So the use of precedents in arbitration, I think, is, of course, an interesting issue, because supposedly tribunals are not bound by each other. They have the right to look at the facts of each case, and the right they have to decide the issue before them based on the individual facts of the case. But of course, when the situation goes to the national courts, for example, for a setting aside proceeding or a recognition and enforcement proceeding, then it becomes a problem, because in some systems, like common law systems, you have the stare decisis principle, which requires courts to follow higher courts decisions. So in those situations, particularly when we are concerning with the application of domestic arbitration statutes, for example, how the Hong Kong Arbitration Ordinance operates, then it will be necessary to look into precedents, to look at how these matters have been decided before. And that's the reason why we have placed so much emphasis in this talk on precedents, because they are providing some guidance as to how a future national court, Hong Kong court, local court will deal with these international arbitration matters. But within arbitral tribunals, I would say precedents are not really precedents in the sense that they are binding, but they are of some referential value, because it will also be interesting to see if they're using the same applicable law. For example, how would a tribunal decide on a particular substantive or procedural matter? I hope that answers the question. I saw a second question now. Yes, Sam.
One little matter. At slide 25.
Yes.
One of the grounds you summarize is any other reason that the court considers just. And you cited the case U&A.
Yes.
Can you briefly mention what was the circumstances of that case?
Yes. So U&A was concerned with a situation, I think it's a Taiwan award. So in that case, the reason why Section 686 is relied on is because it does not fall within the other regimes. In that case, the court was the party has raised a ground under any other reason that the court considers just. So this was a ground which only appeared under Section 86, but not other regimes. So therefore, I've cited this case because the court has rejected the challenge under this ground by saying that what this ground practically means is public policy. What this ground practically means is any other concerns that might be problematic. So practically speaking, it does not add much to the grounds that we already have in the other situations. And therefore, I've just put up a postscript here to say it potentially is a ground that appears in the statutory language, but does not have much practical significance. Reading that case would lead to an impression like that. Thank you, Sammy. Thank you. Let me respond to the second question here. Is it not confusing to see courts from diverse jurisdictions interpreting these matters of arbitrability, conflict of laws, etc., in diametrically opposite ways? Yes, it is confusing, and that's why we need books from different jurisdictions to consider how these matters are decided under different local laws. And that's exactly also the reason why we will need to consider more carefully questions of jurisdiction and governing law in arbitration. Because if we apply a law in which we don't have sufficient information on, then potential questions on arbitrability, on conflict of laws, on recognition and enforcement, or set aside might arise under different circumstances. And therefore, it is important for parties to do sufficient research in order to consider what are their rights or obligations, or what can they potentially do or not do under each of those matters. For example, the Hong Kong Arbitration Act, or so Hong Kong Arbitration Ordinance has in many ways different ways of dealing with things when contrasted with the English Arbitration Act. So it is important to see how these differences could lead to a problem. For example, English arbitrations generally allow questions of appeal against law, which is only opt-in Hong Kong rather than opt-out. So in these situations, parties choosing a particular arbitral seat or a particular governing law for the arbitration would have to consider these matters. And that's why it's important to include express governing law, for example, in arbitration agreements. So that, I think, answers the question. I think we have 4 minutes, less than 4 minutes. I will see if there are any other questions.
Is it correct by choosing an English law, the newest version 2025 English Arbitration Act mandates that if you choose the seat of arbitration as in UK, then the law governing the arbitration agreement would automatically be English law? Is there such a stipulation?
That is exactly
2025.
That is exactly what Section 6A does. So the law governing the arbitration agreement under the new act would be either the express stipulation of the party or the seat of arbitration. So if the seat of arbitration is England, which is usually the case if parties chose English arbitration act to govern the arbitration, then English law would govern the arbitration. But the simpler approach there was the seat of arbitration. Yes.
I just wanted to ask for your views on the HKIArb case.
Yes.
So the supervisory court, which was the CN court, upheld the award based on CN public policy. And then at first instance, Reyes decided that it was against Hong Kong public policy to enforce it. And then the CA said we should defer.
Yes.
But then why should a Hong Kong judge applying Hong Kong public policy defer to a foreign court which has applied foreign public policy when they are conceptually distinct matters?
Exactly. So that makes it a very interesting decision as to how much you want to respect a foreign court's decision on that ground. Supposedly, if that arbitration was conducted based on the procedures or based on the common understanding of how it was conducted in that place, it should be given some consideration on how that might appear. It was often also used as an example to look at how HKIArb might potentially be a problem in the common law system. I remember me asking a common law judge a few years ago about what is his views on HKIArb, and his reaction was, why is this even possible? They don't even think about the possibility at all about how HKIArb could potentially apply. So I don't think I need to take a stance on this, but it's interesting to see how Hong Kong courts decide to give effect to potential foreign decisions looking at the award, which has already looked at the awards. I would say there are reasons for and against that approach, and I personally would say that was a time where the court would want to look more carefully at the court will want to give more deference to the mainland court. But the Song Lihua case, I think, is a good counterexample in that regard, because even though the mainland court has said it is fine, the Hong Kong court decided that our local public policy would not allow for such distraction to be imposed on the arbitrators. So I think there might be a change in judicial attitude in that sense, but HKIArb may be seen as a good reflection of how deference was given in a very substantial way, actually. Good. I think that fills up our time, actually. So I think it's left for Samuel to make concluding remarks.
No, I just wish to thank Wilson for delivering this informative talk.
Thank you.
I'm sure many of the attendants, whether present here or online, may have questions to ask you.
Yes.
Would you allow them to send you questions by email?
Of course, please do. Please do. I'll be happy to receive it.
So, and another issue is that, are you willing to share the PowerPoints?
Yes, I'm prepared to do so. It will be available later on the website, I was told. Yes.
Thank you very much,
Thank
Wilson.
you. Thank you.